Using the court system. Federal court judges have no interest whatsoever in speaking with a lobbyist from an interest group face to face. They also don't have any interest in getting campaign donations. They don't get elected, and they don't have to run for re-election. So interest groups must find other ways to influence the decisions of federal courts in a way that will benefit their common concern. A common way that interest groups will try to use the court system is with litigation. Interest groups will, and litigation by definition is arguing a case in court. So interest groups will pay for and provide legal representation for a person who is fighting in court, and their cause would further the interest group's cause. For example, the NAACP paid for legal representation on behalf of Brown in Brown v. Board. What the NAACP did is they knew that if Brown won this case, segregation in the United States would end. So the best way that they could make sure that Brown won is through the NAACP Legal Defense Fund. They provided a lawyer, some of the best lawyers, like Thurgood Marshall, who later became a Supreme Court Justice, the first African American, and Oliver Hill, to go argue the case in federal courts on behalf of Brown. And when the Brown decision was handed down and it overturned separate but equal, that furthered the NAACP's cause. Another interest group that's really great at litigation and spends a lot of money and time on litigation is the American Civil Liberties Union. If there seems to be a violation of the First, Fourth, Fifth, Sixth, Seventh, and Eighth Amendments, the ACLU will jump in and they will argue and provide lawyers for a case. Another thing that an interest group can do is provide amicus curiae briefs. This means a friend of the court. An interest group can't directly lobby a judge, but what they can do is file a brief. And a brief is literally a file folder of facts and constitutional arguments that go for one side of the case or another side of the case. You're going to file this evidence in support of your interest group's side in court. So when if an interest group wanted to have a say in a case dealing with same-sex marriage, and the interest group is pro same-sex marriage, what that interest group can do is file an amicus curiae brief talking about the constitutional violations of allowing for same-sex marriage, or restrictions of same-sex marriage. Class action lawsuits. Class action lawsuits are when interest groups bring members of their group or even potential group members together, and these people have a common concern and they're going to file a lawsuit as a group. The most common class action lawsuits that you might be familiar with are like the American Lung Association gathering a bunch of people who got lung cancer or emphysema from smoking, and then the American Lung Association will put all of those people together in a lawsuit against the tobacco companies. Okay. And then the last way that interest groups can influence the court system is by influencing the presidential pick for judicial nominees. So they could give, like the American Bar Association can give information to the president about which judges are, lower court judges or constitutional lawyers would be acceptable as a judge on the Supreme Court or on the appellate courts. So they can give information to the president about which judge would be good. Then, once the president appoints that judge of course has to be confirmed or approved by the Senate. And when the Senate Judiciary Committee is conducting hearings or interviews of the presidential appointee, interest groups can provide senators with information about that judge. Sometimes interest groups, if a judge is really conservative, interest groups will form a coalition, like liberal interest groups will form a coalition against a really conservative judge. And this happened in the case of Robert Bork. And I'm going to talk about Robert Bork when we get to the judicial branch. But Robert Bork was an ultra-conservative judge, and a lot of liberal interest groups like the ACLU, NAACP, and the National Organization of Women formed a coalition against Bork and scared some senators into not voting for his approval. Constitutionality and interest groups. So I'm going to talk about this right here. This political cartoon, anything like cockroaches are going to survive the apocalypse, the nuclear, destruction of the world. So these cockroaches are looking over destroyed DC. And they say it all started because of Grover Norquist. And the other cockroach looks and says, "What's a Grover Norquist?" Well, a Grover Norquist is a conservative lobbyist, and it's not a what is, it's a who. He is the super lobbyist for Americans for Tax Reform, which is an interest group who would like to see a more regressive, flat tax, lower tax rates. And, of course, the political cartoonist perspective of Grover Norquist is negative because they're saying that he is the reason why DC is in shambles, according to this cartoon. But you know what? Grover Norquist has the right to assemble. All of the Americans for Tax Reform members have the right to assemble. They have the right to petition their government, and they have the right to free speech. You don't have to like what they say, but you must defend to the death their right to say it. So you really can't shut interest groups up. And that goes back to James Madison's Federalist Paper 10. You cannot get rid of the source of factions because the source of factions are liberty, but you can mitigate their effects. You do have electioneering questions that have come up in Buckley versus Vallejo. Is it okay to limit contributions because contributions are a form of free speech? And in Buckley versus Vallejo, it is okay to limit contributions. But in Citizens United, we kind of overturned that, and the Supreme Court said that you can't limit how much corporations, labor unions, or wealthy individuals give to super PACs or 527s. Want to review influence real quick? What tactics do interest groups use? Remember, the most important tactic they use is providing information, testifying at congressional hearings, whether it's about a law or about a Supreme Court nominee, providing information to government agencies. It is the most important tactic to influence lawmakers, is giving them credible, reliable, yet biased information about your cause. Influencing elections through PAC money and independent expenditures, we are seeing an increase in the amount of money we're giving. Most of the money goes to incumbents. But the reason why it's not as effective as information is because interest groups donate to both sides of the aisle. They donate to both challenger and incumbent because they want to make sure they have all of their bases covered. Money is an expectation, not an influence. And they give money to the executive branch too, as far as helping the president get elected. All right, litigation and amicus curiae are ways that we or interest groups influence courts, regulating their influence, revolving door. Before you can leave Congress and go work for an interest group, you have to wait 2 years. So you can't directly go straight into an interest group from Congress. You got to give it some time. And disclosure, disclosure, disclosure. Who are you talking to? Who are you giving money to? And if you're a Congress member, who's talking to you? Who's giving you money? All of that tries to end this cartoon right here, which just says congressional parking lot. You have all these fancy cars, and each one of their license plates have a type of business on them. Like I think this one says dairy. All right, so like the dairy industry gives money to that congressional member. So that's key. Money is not as important as information, and information really drives the interest group's influence.